Hello viewers, welcome to this session at Gyan Darshan. I'm working with Insolvency and Bankruptcy Board of India. My name is Dilip Khandale, and along with me I have my colleague Ms. Archana Sharma, who is a manager with IBBI. Topic for our today's discussion is the role of insolvency professionals under the Insolvency and Bankruptcy Code 2016. In our lecture today, we'll cover the appointment, tenure, and role of insolvency professionals with respect to corporate insolvency. But before I proceed, let me briefly touch upon the issue of corporate insolvency. As we all know that corporates or a company is an amalgam of many stakeholders, and every stakeholder has a unique set of expectations from the company. For instance, shareholders of the company expects capital appreciation and good return on their investment. Creditors of the company expects that company pays interest on time and repays the principal amount of debt on time. Employees of the company expects career progression, growth along with the company, and workers of the company expects job security and payment of bonuses. Similarly, suppliers of the company expects repetitive orders from the company, and customers of the company expects that company produces the goods which are of quality and then makes available to the customers at the reasonable prices. In fact, government and society are also the important stakeholders. Government expects that company pays the taxes and contribute to the nation building process, and similarly society expects that company runs the business in an ethical manner. So when business of the company runs smoothly, company is able to meet most of the expectations of most of the stakeholders. But companies do operate in a dynamic business environment, and business of the company may get affected because of many factors. It may get affected because of the intense competition which is prevailing in the market. Business may go also affected because of the changes in technology due to innovation. It may also affect because of the change in taste, habit and preference of the consumers. And quite often, business of the company severely gets affected because of any internal mismanagement of the resources of the company. But irrespective of the reasons, when business fails, it has a very destructive impact on the stakeholders of the company. For instance, when business starts failing, plants of the company remain underutilized. Company's revenue go down, profits are drained, company is not able to generate adequate revenue to meet its expenses. Company is unable to make payment of its dues to the creditors on time. Lenders of the company refuse to lend additional money to the company. Similarly, credit rating of the company gets downgraded and company is not able to borrow the money from the market. In fact, as a result of this, company's plants are ultimately shut, employees and workers lose their job, and suppliers and creditors lose their money which is involved in the company. So it is very necessary to address the issue of corporate insolvency, and at the same time it is also very necessary to ensure that to rescue the companies which are viable, to shut down the companies which are not viable, so that resources like man, machine, capital can be put to alternate use. And at the same time, it is also very necessary to balance the interest of all the creditors, because when corporate insolvency happens, every stakeholder wishes to get the maximum share of the resources which are now left with the company when the insolvency happens. Now, Insolvency and Bankruptcy Code 2016 provides a unique solution to this problem of corporate insolvency. We have listed some of the key features of the Insolvency and Bankruptcy Code 2016 over here. The first important feature of IBC is its applicability. I'll be using the word IBC or a code for the purpose of convenience. So applicability. If you look at the preamble of the code, it says that this is an act to amend and considerate laws relating to reorganization and insolvency resolution of corporate persons, partnership firms, and individuals. It means that IBC is not only applicable to the corporates, but also it deals with the insolvency proceedings of the individuals. So in short, IBC is a complete law. Now, if you look at the objectives of the code, objective is that reorganize and resolve the insolvency of the corporate persons and individuals. But this is done for maximization of value of assets of the company, for promoting the entrepreneurship, making availability of credit, and at the same time balancing the interest of all stakeholders. And for this purpose of maximization of value of assets, the code envisages that there is a preservation and protection of the value of assets of the company, and at the same time there is an optimum utilization of available resources with the company. Now, if you look at the third important feature of the code, is that the control. See, company is funded out of debt as well as equity. As long as the debt is serviced, equity has a complete control over the company. But when insolvency happens, the code shifts the control from the existing management to the creditors of the company for resolving insolvency. So creditor in control regime is something which is established by the Insolvency and Bankruptcy Code. Another important feature of the code is the linear processes which are established by the code. The code requires that the company to compulsorily undergo a corporate insolvency resolution process when the first default happens. Why this is done? So that the creditors of the company can sit together and work out the resolution plan to rescue the company. And when this rescue, when the CIRP fails, the company goes into the liquidation. It means that the code provides for the resolution of the insolvency over the liquidation by compulsorily requiring the CIRP to be conducted in a time-bound manner. Another important feature of the code is the timelines which are given in the code. The code requires the creditors to work out the resolution plan in a time-bound manner of around 180 days. A one-time extension of 90 days is provided, but if that resolution plan is not worked out within the given time frame, then in that case, the company goes into the liquidation. So the code requires creditors to sit together and work out the resolution plan in a time-bound manner. And the most important feature of the Insolvency and Bankruptcy Code is the ecosystem, what we call as the 4 pillars of IBC, which the code establishes. The first such key pillar of the IBC is the adjudicating authority. These are basically the specialized courts which deals with the insolvency proceedings of the corporate persons and individuals. In case of corporates, it is the National Company Law Tribunal, NCLT, which deals with the insolvency proceedings of corporates, and in case of individuals, it is Debt Recovery Tribunal, that is DRT. Now, the second important pillar of IBC is the information utility. This is a brand new industry, and this is basically an information repository wherein details of debt, the lending terms, debtors and creditors information is stored in an electronic database. And the purpose of this information utility is that the defaults and disputes can be eliminated while establishing the default in case of an insolvency petition. Another important feature of the key pillar of IBC is the insolvency professional. These are basically the regulated class of professionals registered with IBBI. These are the individuals who are basically dealing with the insolvency proceedings. They play a very important role in corporate insolvency resolution process and the liquidation process. And the last and the most important pillar of the IBC is the Insolvency and Bankruptcy Board of India. Basically, it's a regulator which regulates the industry of information utility and the insolvency professionals. Now, before we talk about the role of insolvency professionals, let us understand who is an insolvency professional and how the insolvency individuals are becoming the insolvency professionals. Now, if you look at the definition of the code, which is the insolvency professional means a person who is enrolled with a insolvency professional agency as its professional member and then registered with the IBBI as insolvency professional. So basically, the code provides for a dual regulatory structure in case of insolvency professionals, where the insolvency professional agencies are the frontline regulators of the professional members, and the Insolvency Bankruptcy Board of India is the principal regulator of all the insolvency professionals. Now, there are 4 stages for becoming an insolvency professional. Insolvency Bankruptcy Board of India has notified the IBBI Insolvency Professionals Regulations 2016. In short, we call it as IP regulations. These IP regulations basically governs the process of registration and regulation of insolvency professionals. Under these regulations, it is required that only individual can become an insolvency professional. And at the same time, this also provides for qualification requirement, education requirement, and other requirements, eligibility requirements for becoming an IP. So for the first requirement is that limited insolvency examination. Individual has to clear this limited insolvency examination, which is mandatory for becoming an IP. It is basically conducted in an online mode. The main syllabus of this examination mainly covers the code, the rules and regulations notified by the IBBI as well as the other business laws. It's basically conducted in a multiple choice question format. It carries 100 marks and one has to secure 60% marks to pass this limited insolvency examination. Once you pass the limited insolvency examination, you have to approach any of the IPA for obtaining enrollment as a professional member. Next stage is that you have to complete the pre-registration education course. Basically, this is a 50-hour course which is conducted by all three IPAs jointly through an online mode. This course basically is intended to brush up the knowledge base and the managerial skills of the individuals in handling the insolvency cases. And the last stage is obtaining the registration in IBBI. Now, as far as the qualification and experience concerned, the insolvency professional regulations says that there are two requirements. One is the experienced individuals. The individuals who are having 10 years of experience as chartered accountant, company secretary, cost accountant, advocates, they are eligible for seeking registration as an insolvency professionals. At the same time, individuals who are having 15 years of experience in management, they are also eligible for registration as an IP. Additionally, the individuals who have 10 years of experience after obtaining experience in the field of law, after obtaining degree in law, they are also eligible. And individuals who are having 10 years of experience after obtaining master in business administration and 2 years full-time postgraduate degree program, they are also eligible. Apart from this, the individuals who do not have experience, however, the students who have completed the graduate insolvency program, they are also eligible for seeking registration as an IP. Once you become an IP, insolvency professionals are handling the assignments. They are dealing with the insolvency proceedings. In case of corporates, they are playing a role as an interim resolution professional as well as liquidator. And in case of individual insolvency, they are working as resolution professional and bankruptcy trustee. Once you become an IP, there are requirements for practicing. So an individual has to have authorization for assignment. Without authorization for assignment, one cannot accept any assignment under the code. An insolvency professional has to follow the code of conduct, which is given in the insolvency professional regulations. Basically, the code of conduct requires insolvency professional to act with independence, act with objectivity, to maintain integrity, to charge remuneration in a reasonable manner. Similarly, the IP has to complete necessary continuous professional education to maintain the registration in the IBBI, and that requirement is IP has to have minimum 10 credit hours in a year and minimum 60 credit hours in a year for continuation of his license. Now, as I mentioned earlier, that insolvency professionals play a very important role in case of corporate insolvency. Basically, they communicate and coordinate with all the stakeholders. Insolvency professionals are the first individuals who basically communicate with the creditors of the company when the insolvency proceedings are initiated. They coordinate with all the other stakeholders of the company so that company remains as a going concern. They also play a very important role in running the processes like CIRP and liquidation processes. And the most important thing is that insolvency professionals have to balance the interest of all stakeholders while dealing with the insolvency proceedings. Now, for next part of the lecture, I'll request my colleague Ms. Archana to continue.
Thank you, Mr. Khandale. So now we will be discussing in detail about the appointment of an insolvency professional in the corporate insolvency resolution process, his tenure, and the main activities which he is required to perform in a CIRP. So, corporate insolvency resolution process, or CIRP in short, this process can be initiated on a petition filed by three sets of applicants. So, one is the financial creditors, who are the bankers, lenders, financial institutions, and the other transactions which involve the consideration for time value of money. Another set of applicants are the operational creditors, who are basically the suppliers, the government, the employees, and the workmen. And the last set of applicant is the corporate debtor itself, which we call as the corporate applicant. So the code mandates the financial creditor and the corporate applicant to propose the name of an insolvency professional who would be acting as an interim resolution professional. But for the operational creditor, the code provides an option that they may propose or they may not propose the name of an interim resolution professional. So wherever the name is proposed, the adjudicating authority, which is the NCLT, it appoints the interim resolution professional provided no disciplinary proceeding are pending against him. And where the name is not proposed by the operational creditor, in such case, the reference is made by the adjudicating authority to the IBBI, the board, who is required to recommend the name of an insolvency professional who can be appointed as interim resolution professional. Now, if in all the cases, we would note that the final appointment is done by the adjudicating authority. Now, if we talk about the appointment of resolution professional, so the committee of creditors, which is constituted under the code, so the committee of creditors in its first meeting, it can either resolve for the continuation of the interim resolution professional as the resolution professional, or it can resolve that the interim resolution professional, he should be replaced with another insolvency professional who would be acting as the resolution professional. So this resolution has to be passed with the 66% voting share of the financial creditors. And if there happens to be any delay in the appointment of the resolution professional, so in such cases, the interim resolution professional who was already handling the appointment, he will continue from the 40th day of the insolvency commencement date. So we consider the insolvency commencement date as the date on which the order admitting the petition, which is filed by the three applicants, any of the three applicants, it is admitted by the adjudicating authority. So now coming over to the next part about the tenure of the interim resolution professional and the resolution professional. So the tenure of interim resolution professional starts from the beginning of the CIRP when the order admitting the petition is passed, and it continues till the resolution professional is appointed under section 22. And the regulations which govern the corporate insolvency resolution process, the IBBI Insolvency Resolution Process for Corporate Persons Regulations 2016, in short the CIRP regulations. So they also provide, in case there is any delay in the appointment of RP, so from the 40th day of the insolvency commencement date, the IRP shall continue to act as the RP. So if we have an overview about the activities which are conducted by an insolvency professional as IRP or the RP in a CIRP, so first it starts with the communication with the stakeholders. So the stakeholders could be the adjudicating authority, it could be the corporate debtor itself, it could be the various creditors, the various debtors or other stakeholders. Then once the IRP is appointed, he is required to make the public announcement. The purpose of the public announcement is to make the creditors aware that the CIRP has been initiated so that they can submit their claims as per the timelines. So once the creditors they submit their claims, the IRP is required to constitute the committee of creditors and file a report certifying the constitution before the adjudicating authority. Then he is required to conduct the meetings of the committee of creditors, and there are other certain set of activities which he is required to undertake in this CIRP. So these activities include the appointment of registered valuers, preparation of the information memorandum, then issuance of the expression of interest, and examine certain transactions which are in the nature of preferential, undervalued, fraudulent or extortionate. And then he also examines the resolution plan and also put forth the same before the committee of creditors and file the applicable applications before the adjudicating authority. So this was an overview of the key activities which are undertaken by an IP in a CIRP process. So one thing which is to be noted is that these activities, they are not to be considered to be undertaken as one by one. So these activities, they are to be conducted parallelly along with the operations which are to be conducted by the IP, the operations of the CD, so that it remains as a going concern. And it has to be ensured that the activities are undertaken as per the timelines which are stipulated under the code as well as in the applicable regulations. So if we talk about the activities of an IRP and a CIRP, so he's required to collect all the information relating to the assets, relating to the finances, relating to the operations of CD. Because he has to manage the operations of the CD, he is required to take control and custody of its assets, and he replaces the board of directors. Then he also makes the public announcement. He invites the claims and constitutes the committee of creditors as we just discussed. Then coming over after the 40th day, as we mentioned, the IRP hands over the entire information documents to the resolution professional who carries on the other activities which we just discussed, the information memorandum, the expression of interest, the examination of the resolution plans and the avoidance transaction and filing of application to the adjudicating authority. So if we talk about the role of an IP, so the Honorable Supreme Court has aptly held in the matter of Swiss ribbons that RP has no adjudicatory powers, he has only administrative powers as opposed to the quasi-judicial powers. He is really a facilitator of the resolution process whose administrative functions are overseen by the COC and by the adjudicating authority. And another important thing, the BLRC, the Bankruptcy Law Reforms Committee, which conceptualized the code, it has laid emphasis that insolvency professional is a key ecosystem in the IBC framework upon which the entire effective, timely functioning as well as the credibility is rests upon. So with this, we conclude this session. Thank you.
Thank you very much.